Okay, good morning everyone, and welcome to the latest version of our EIA webinar, Environmental Impact Assessment webinar series, obviously part of the wider National Planning Improvement and sitting within the National Planning Hub. So we're on our fifth webinar of the series if you've been taking part in the whole course. If not, you can go back and access the previous webinars, and I'll tell you a little bit more about that shortly. Today we're looking really, I suppose it's the subtitle, frankly, more than the main title there, from developer submission of the EIA report through to the consent decision, and in fact, actually just ever so slightly beyond the consent decision in terms of the decision notice and the information that the EIA regulations expect us to put out there. But a nice concise focus was kind of EIA reports having had screening and scoping as the previous focus. So welcome everyone. Welcome if you're new or if you're joining us again. I'm Josh Fothergill. I'm the founder and director of Fothergill Training and Consulting, and I've been brought in as the EIA expert by the National Planning Hub in order to take this work forward. I've got around, well, over 20 years experience in environmental impact assessments, and a lot of that focusing on capacity building, both in terms of kind of webinar type activities and training, but also in terms of research, producing the UK's EIA quality mark, which is a voluntary code of practice that organisations, often consultancies who do the EIAs, can become registered to, as well as contributing to a lot of guidance documents as well. And I'm a fellow of the Institute for Sustainability and Environmental Professionals that used to be known as EIA, and I do quite a bit of volunteering for them. So I will mention we'll mention a few guides later on, and in our next session in a couple of weeks' time, we'll be talking about, or briefly talking about, climate change and EIA, and I'll give you an update on some changes that are forthcoming in that particular piece of guidance. So our agenda for today, well, we're doing this welcome to begin with. I'll run you through a little bit about the National Planning Hub and talk about the housekeeping, particularly how you can ask questions. We'll then move on to the main focus, the slides, EIA reports from developer submission to consent decision, and that will run for probably until about 11:20, and then we will move on to our live Q&A. And we can keep that open until 11:45 if there are sufficient questions and interest. Obviously, if we're all satisfied before that, then we don't have to stay on quite so long. So just in terms of the National Planning Hub itself, the National Planning Hub is this Scottish Government activity, and it's run in partnership with the Improvement Service, as you can see in the top right-hand corner of the slides. And it is very much about enhancing planning across Scotland's planning authorities and responding to the challenges that you guys face as planning officers. One of those that was highlighted in research for the Planning Hub and for the Improvement Service was issues around significance, issues around dealing with environmental impacts, and obviously with both of those linking into EIA. And therefore, that's where we've begun this activity. And back in October, the Improvement Service commissioned myself, Fothergill Training and Consulting, supported by Brody's LLP, the legal firm that many of you will be aware of in terms of planning, and Neil Collar within that firm, to deliver the training series, which is not just these webinars, but is also the web pages. You can see a version of that here. We now have the course kind of outlined on the top page, then the introductory pages where you can find those first two recordings from back end of last year, and then screening and scoping. And there are various different content within these. So scoping is the latest that you can see on the pages at the moment, and there will shortly be a process diagram coming forward in relation to that. And just to highlight, as part of the series, we did a baseline survey back in October and November. We're now, as the series is coming, well, in a month's time, we'll be coming to the end of certainly this phase of the contract. We're doing a kind of reflection survey, kind of what's the impact, the initial impact of this been. So that survey is going out to your heads of planning, your development management leads, and your policy leads this afternoon, and then hopefully we'll cascade down to you shortly thereafter. It's going to be open for a couple of weeks till the 13th of March, but if you get that through and you have the time to fill that in, it'll take less than 5 minutes. Be really, really helpful, both both in terms of understanding the impact we've had, but also in terms of planning any future support that we might be able to offer. So just in terms of housekeeping for this particular webinar, your microphone and camera have been disabled for the session, but we are recording the session, so it is going to be shared. The slide section, at least anyway, will be shared as part of the training course. The Q&A at the end, we will exclude. The idea from the recording, the idea for that is that it gives you more freedom to ask the questions without any worry. In terms of those questions, please use the Q&A button, which should be on your screen, looks a bit like this rather than chat. So if you can use that to post questions about EIA and what I'm talking about, that would be great. If there's any issues with that, you can use the chat, but we'd prefer to keep the chat function there for any technical issues if you can't hear me or you're not getting access to the slides or that kind of thing. So please use the Q&A section. You can do that as we go along, or you can do that when we open up the Q&A at the end as you feel. And Andy from the National Planning Hub will come in and ask those questions on your behalf to me in around 45 minutes time. So I look forward to those. Right, well, let's move on to the focus of today, and it's all about examining the EIA report, and not just the EIA report, but the consultation responses that get generated from that. So we're looking at, I suppose, the most busy period for yourselves as planning officers, as a planning authority, managing that process from the developer's submission of their application with its EIA report all the way through to the consent decision and what we're doing post-consent in terms of that decision notice and the environmental information that needs to be related to that. So what we're going to look at today in terms of learning objectives, understand what makes an EIA report. Just because a developer submits something that they've called an EIA report doesn't make it that in law. That's something that you guys need to consider as part of the validation process. Not usually something that's going to take a huge amount of your time, but it is something important to be aware of. And then we're going to move through those different areas, so the key compliance activities and the sequence of those when you're managing an EIA developments application. So EIA development being a proposed development that requires environmental impact assessments, how we approach the examination that you guys need to conduct of the EIA report and the other information, particularly the consultation responses, the role of additional information, and within that, your powers to request supplementary information in relation to the EIA, and then we'll give you some advice, where to look for guidance and some hints and tips as well, particularly around that examination process along the way. So let's crack on. So just a refresher to get us back into the headspace of environmental impact assessment. We're not doing it for every application. In fact, it's really quite a small number of applications that are going to come to your planning authority, but it's a decision support tool that's applied before we determine planning permission. And it's for those developments that are likely to have significant effects on the environment. It is something that comes out of legislation, and therefore it applies not just to the planning system, but also to many other consenting systems. But of course, today we're focused on its role in the planning decision and that application process. And there are other, of course, environmental requirements that are set out within policies that will be applied to many more applications than those that require EIA, but where EIA is required, it's going to apply a more rigorous approach, a more structured approach to the environmental assessment, both of risks to the environment, but also of risks to, or certain risks to communities because of the breadth of definition of environment, and we'll come on to that in a few minutes' time. So if you've been watching the series from the start or through, you will recognise this diagram because we've had it up, I think, each time now. Where are we focusing today? So we've had our development proposal, we've screened it to say, yes, it does require EIA, or our developer has indicated they're going to produce an EIA report, so it didn't need to go through that process. We've scoped it, so we've identified what is going to be inside it, or the developer has done that, and we might have issued an opinion if requested. The developer has done their assessment, and they've produced their EIA report, and that's where we're going to start off today. They've produced that EIA report and they've submitted it to us. There's going to be a requirement for consultation, a requirement for us as a planning authority to examine the environmental information. And I'm not saying environmental information in a general sense there, that's a particular prescribed word defined within Regulation 2. We'll come on to that in later detail. And then we'll look at the consent decision itself and really just look at the decision notice. We're not going to get too far beyond that today. So why is all this important? Well, obviously, EIA is a procedural, it is a process-driven piece of regulation. That was very much the approach back in the 80s and 90s where EIA was developed. We're perhaps now a bit more outcome-focused. However, we therefore need to make sure that these various duties are complied with in order to enable us to produce a compliant and timely consent. So if you were watching webinar 3 around a month ago at the end of January when we were talking about screening, there was a lot of focus on regulatory procedures and requirements, and I'm afraid to say we're going to be back in that kind of vein today. However, the ambition is to make it reasonably interesting or engaging so that you can follow it and understand the sequence that fits there. Ultimately, the crunch for you guys is to form the planning authority's reasoned conclusions on the proposed development's significant effects on the environment and get those integrated into the actual consent decision process. So if it's not been deferred to yourselves, then if it's going to planning committee, you guys are going to do all the work as the planning officers, but it's making sure that those reasoned conclusions on significant effects are available and considered to support the decision. Remember, EIA being decision support when the decision is actually made. And numerous kind of procedural requirements to be aware of. I guess a key one to be aware of is where we're doing an EIA or where we have an EIA development application, timely decisions are extended to 4 months versus the standard 2 months, but there is an awful lot to do within that. So we've got extra activity to deal with the EIA report, the procedures, the consultation. So we get an extra 2 months for that, great, but 4 months is really not very long to deal with this. Obviously, after that 4 months, there is the possibility that the applicant could submit an appeal against a kind of deemed refusal, but you know they may be not seeking that and are happy to await your decision. But we need to be aware, you know, there is that expectation. So whilst EIA is decision support, it does have some teeth, and we have mentioned these before in terms of these regulatory teeth. So there is a prohibition within the Town and Country Planning EIA Scotland regulations, 2017 as amended are the ones that we're working on, and that prohibition is to grant planning permission or the approval of matters specified in condition, or as EIA calls them, multi-stage consent. We're prohibited from granting that planning permission if the development requires an EIA and it hasn't undertaken the full environmental impact assessment process. And that's defined, and we'll talk about what that is on the next slide. So meeting those regulatory definitions of EIA is really critical, and those regulatory definitions of EIA really start with the submission of the developer's EIA report. So even though we'll have done a lot of activity in relation to the EIA potentially before this stage, actually the formal kind of definition of EIA is only starting with that submission of the EIA report. So failings to achieve this definition and these requirements are where people could begin to approach a consent that's been awarded and look to base a judicial review or seek a judicial review based on EIA grounds. So what is that definition and where is it? It's in Regulation 4.1 and it's A to E. There are, of course, other components within the EIA regulations that are important to get right as well, but this is the absolute kind of crux or the core of what EIA is defined as. So the preparation of the EIA report by the developer, and then it's really all over to yourselves as part of the application management process through to decision. The carrying out of those consultations, publication and notifications that set out across parts 5, 6 and 10 of the regs, the examination by yourselves, or if it's an appeal or it's been brought into the Scottish ministers by them, but you know, we're going to focus on yourselves as planning authorities today. So your examination of the information that's presented, the EIA report and other environmental information. from that examination, coming to reasoned conclusions as to what the significant effects are, and integrating those recent conclusions into the decision notice and therefore into the actual decision itself that then carries through to that notice process. So as you can see, the definition of EIA, there's an awful lot of work gone into the preparation of the EIA report. Screenings occurred before that, scoping, etc. This is really where we get into the crux, and therefore why it's important to make sure we're meeting these requirements. And just as a reminder, in terms of what we mean by environment, we're required as a planning authority and as planning officers going through this process and conducting the examination to consider and be aware of the likely significant effects across a range of factors that are the environmental factors or the minimum environmental factors that EIA should consider. So you can see them there. It's quite broad-ranging: population and human health, biodiversity, land, soil, water, air, climate, material assets, cultural heritage and landscape, and equally the interactions, if there's interactions. So the project is going to lead to emissions to air. Those emissions to air are going to rain out of the air into onto the land, run off the land into the water, and then go downstream and reach a protected ecological site. Then that could be an interaction where a significant effect is occurring. So it doesn't just have to be the project directly on biodiversity, it can have these links across. You will note noise, transport, socioeconomics, things that are regularly found in EIA reports aren't necessarily specified within the legislation itself. So if we're trying to draw a significance conclusion, we want to be linking it back to a kind of receptor. So, if it's noise, is it an impact on human beings, the population, the human health, or is it an impact more on protected nature and biodiversity? Or could it even be, vibrational impact on a cultural heritage asset or those kind of things? So that's what we're trying to draw ourselves to in terms of those significant effects. So it's absolutely fine for those topic chapters to be there. They're more about, I suppose, the pathway of the effect rather than the receptor that's affected, or at least that's what they're titled around. So let's move on to that process and start thinking about each of those steps and what we need to do in relation to them. So firstly, we're going to think about receiving that EIA report, that EIA development application, and checking that what is claimed to be an EIA report is actually so. So an application comes in. Hopefully we're already aware that it's going to be coming in soon, and we're already aware that it needs EIA, but that isn't always the case. So the two key activities we need to be doing around EIA when the application comes in is, one of them is checking, is it an EIA development? Now that's obvious if it's had an EIA report submitted to it, but the reason I bring this one in is there can be times where we have developments come forwards that didn't seek a screening opinion. So the developer didn't make a screening request earlier to say, does EIA apply? And they can be a Schedule 2 development. So they can be a development that needs a decision from the planning authority as to whether EIA is or isn't required. So we need to be aware of that for our applications that sit above the Schedule 2 thresholds, or if we're in sensitive areas, they meet the requirements or they meet the description in column 1 of Schedule 2. So we need to see, has it been previously screened? If it has, and we indicate that EIA is required, great. We're just now checking, is an EIA report submitted? And we can move on to our second step of, is that EIA report actually meeting the requirements? But if we haven't screened it before and it's above Schedule 2, then this is the point where we're expected to screen it and make sure that we've got a decision on record to either indicate it isn't EIA, in which case we can obviously progress with the application. But if we do find EIA is required at that stage, then we're not going to be able to accept that application. We're going to have to tell the developer an EIA report is going to be needed, and they'll obviously need to produce that before they can make that application. So let's assume we knew it was an EIA development, it's come in, it's got an EIA report with it straight away. That's the easier process. So one thing we do need to be checking, and probably as part of the kind of validation process that you guys are doing in terms of application, is just because someone scribbles in crayon on the front of a piece of paper EIA report does not make it an EIA report in the eyes of the law. So it is the requirements of Regulation 5.2 A to F that set out the minimum content requirements to make a document legally an EIA report. So what's in there? Well, it needs to set out information about the proposed development, its site, its design, its size, other various factors, the likely significant effects of that proposed development on the environment, anything that they've done in terms of the design or in terms of proposed mitigation measures that would act to reduce, avoid, prevent, offset likely significant adverse effects. Consideration if the developer has looked at any alternatives, then what were those alternatives, and an indication as to why this application has come forward as opposed to those other developments. And if the environment has played a role in that, then obviously that would be covered there. And then there needs to be a non-technical summary, a kind of more publicly accessible version of that core information. The other requirement, and this is where it does spread its wings quite a bit further, is if there's anything specified in Schedule 4 of the regulations about particular characteristics of the development or environmental features, if they're relevant, then they become part of the formal requirements for the EIA process. And this can be a little bit of an opportunity as well to check the document has met a previous scoping opinion that you might have issued. In terms of Schedule 4, we don't have time to go through the details of it today, or at least I didn't think that was the best use of our time to go through those details today. So I've just given you a kind of screen grab of it here. But what it's effectively providing is kind of additional information or content in relation to those core things that I previously read out. So about the development, about alternatives, about the baseline environment, about the type of environmental effects. And then if there were challenges in the forecasting methods, those can be highlighted, mitigation measures, and then a description of kind of if there are any particular vulnerabilities in terms of to accidents and disasters, etc. So if these are relevant, they become part of the expectations. So we should be checking just quickly to say, does this document actually look like an EIA report? Has it got these components and contents within it? And that will become important in our next session on the 12th of March when we're talking about Section 42 applications. But for now, we'll just leave that there. So other compliance requirements that are there and existing in relation to the submitted EIA reports. If there's been a scoping opinion, so if the developer voluntarily asked you for a scoping opinion, then the EIA report needs to be based on the latest scoping opinion. That isn't totally binding. It doesn't have to follow it specifically until the letter, but it has to be based on. So if they've utterly ignored vast things that you asked for or were highlighted by the statutory consultees and you included in your scoping opinion, then it gives you the basis to say, actually, this isn't good enough. Good practice obviously would be that the developer actually, if they've received an opinion and deviates from it, they explain that within the EIA report, and that's pretty easy to find within the contents. Some are very good at that, put a table in, here's what the scoping opinion said in terms of issues, here's where they're dealt with, here's where we've varied from them. Others, it's a little bit more choose your own adventure. Obviously, you could ask in your scoping opinion for such a table. There's meant to be an avoidance of duplication where that's possible, so the EIA report can cross-refer to other relevant assessments, which includes seeking to kind of coordinate if there's a requirement for an EIA and a habitat regulation assessment, or an appropriate assessment, as you might call it. So the EIA report's findings should be consistent, really, with that HRA report or shadow HRA report that the developer has submitted. Of course, this doesn't allow them to entirely exclude content. So you can't say, well, look, the baseline already exists somewhere else, so we're not going to cover that. There's a minimum expectation in terms of what should be covered, but if we can rely on certain findings to reduce and focus our activity and content in the EIA report, that is allowed. And then the final expectation is that the developer has used competent experts to produce the EIA report. And most of the time that is going to be a consultancy or a number of consultancies with coordinators running the EIA process who are expert in that, and topic experts as well. There has been a requirement since 2017 that the EIA report must therefore include a statement explaining how the developer feels they've met that competent expert requirement. Usually that's going to be an appendix with a bunch of CVs in it, certainly for the lead of the EIA report and also for the chapter leads, possibly for everyone who's been involved in the process. So you want to make sure that something is said somewhere about it, but you probably don't want to worry too much about that in the detail of things. So once we've got through kind of checking, yes, this is an EIA report and it is a project that requires EIA, then we need to move on to the next stages. We've got the application in. What does the EIA process expect of us now? Well, it expects us to do some consultation and set out some notices, and then there are three kind of sub-activities within this. So notices to those on neighbouring land, publication of the EIA report, and then consultation on the EIA report is how the regulations set this out. I've set them out as kind of the third activity because our first was checking, is this an EIA project or not? The second was checking the EIA report actually is an EIA report, and that should be quite a quick check. And this third one is getting onto these notices and making sure that they're all happening. So the first one is literally about kind of a notice of the EIA application to those on neighbouring land. Neighbouring land isn't defined in the EIA regs. It has the same meaning as set out in the Development Management Procedure Regulations. So under Regulation 3.1 of that Development Management Procedure Regulations, neighbouring land is defined, and you'd use the same definition for these notices. So where there's premises situated on neighbouring land, around the application site, then we need to provide a notice to those premises, and that is set out in Schedule 5 of the regulations. So you just kind of making sure they've got that notice, and that's telling them this application's in, there's an EIA report, etc., etc. So that's the notices. In terms of the publication of the EIA report, well, you as the planning authority need to organise the publication of the EIA report notice. That would be on the application website. So that's a website maintained by yourselves. So effectively that's going to be on your planning portal or whatever it's called. The Edinburgh Gazette, the kind of national kind of statute record book, and a newspaper that circulates in the locality of the proposed developments. So it isn't either or of those, it's all three of those is where you've got to make sure that the EIA report is posted. The developer pays these costs, by the way. So Regulation 21.4 sets out that the developer should be paying your costs for that notice in the Gazette and the newspaper. And what that notice needs to cover, well, there's quite a lot of detail to it, and I'm not going to jump through all of that today in detail, but it's kind of summarised there on that bullet, and you can find it in Regulation 21 to A to H. And you'll probably already have a template that you would be using in relation to this, but probably useful to check that that template is aligned to what is stated here. Sometimes those templates will be carried forward and forward and forward. Maybe they didn't quite get updated in 2017 to the new regulations. So sets out proposed development application, the fact that it's an EIA development, the existence of the EIA report, and then obviously information about the consultation and the ability for people to respond to that. So we need to make sure that publication goes out. And then finally, there is the consultation that is obviously enabled by some of those notices, some of those publications, etc. So in terms of the consultation, we need to send copies of the EIA report to the Scottish ministers, the consultation bodies, and other bodies. And the other bodies are defined in that middle section of the page there. So this is an expectation on us. Obviously, if the developer has already done this and they've provided evidence of this, then I guess that is useful. But the expectation from the regs is placed on us. So consult on the EIA reports and the application with the consultation bodies. Remember, those are from the Regulation 2. So it's SEPA, it's your neighbouring planning authorities, it's Historic Environment Scotland, it's Nature Scot, and it's Scottish Water. You've then got to consider whether these other bodies are relevant. So the Health and Safety Exec, the Nuclear Regulation Body, and then any other public body that you feel might be interested in the application because of its particular environmental responsibilities or its local or regional kind of competencies or expectations upon it. So there's a little bit of thinking for you to do there to say, okay, we sent it to the core EIA statutory consultees, but are any of these other people, other organisations needed to be involved? And then the public and interested parties also get the opportunity, but this is via the kind of notice and the publication that goes out in relation to that. So, the Edinburgh Gazette, the local newspaper, the online content, etc., is covering this. And you publish it on part 1 of the register and need to make sure that it's available on the website and at the planning authority's main offices. In terms of the length of time, the regulations indicate 30 days after the advert's published, the notice goes up, it's been sent to the consultation bodies. So technically there's going to be a whole number of different clocks running at this stage, because if you sent it out to SEPA on Monday, but it doesn't go out to Nature Scott until Friday, and then it doesn't appear in the local paper until a week on Thursday, then those 30 days are obviously running from those different start points. And the reason it says 30 days plus 1 there is, in terms of the absolute kind of in order to make your decision, you should always give that extra day, 30 days after the notice is published. So 30 days plus 1 in terms of the date when you could, in theory, start making your consent decision. Of course, you do need to examine the content of what has come back from those statutory consultees and the public. So in all likelihood, it's going to be sometime after those 30 days that in reality, you can actually make a consent decision in order to enable the process we're about to talk about. So this process of undertaking the activities, the site notice, the publication, the communication, and the consultation, etc., all of this is to generate what the EIA regs call the environmental information. And the environmental information isn't just a nice term that I'm using, it is something that is defined within Regulation 2, and it's what you're required to examine in order to come to your reasoned conclusion. So it's within that core definition of what EIA is and what therefore you need to procedurally deliver to remove the prohibition to grant consent. So the environmental information is the developer's EIA report. It's any additional information that they might submit in respect of the development. And again, additional information is defined, so we'll talk about that on the next slide. So the EIA report, the additional information from the developer, any representations that are made either by the consultation bodies, the other public bodies that you might have chosen to involve, and any representations that are made by any other person about the environmental effects of the development. So obviously that would be the public, etc. But it could be that they respond in relation to the planning application and they're talking about the environment. That is still relevant, even if they're not specifically referring to the EIA report. If they're talking about environmental issues related to the application, then it is part of the environmental information. So what do we mean by additional information by the developer? Well, again, this is defined in Regulation 2, and additional information can be information that you request through a supplementary information request. We'll come on to that later on because that comes a little bit later in the process once you've started examining this information. But equally, it can be any other information that's provided by the developer, which in your opinion is substantive in relation to a matter that's set out in the EIA report. So if it's substantive new environmental information that hasn't previously been there, then it is additional information and it can therefore trigger a requirement for additional consultation if it comes in after the EIA report's consultation has started. So this is another important judgment if the developer is sending new content in. And occasionally it happens, they'll send in the EIA report and all the heritage chapter appendices for some reason never got uploaded onto the planning portal, and therefore they weren't there, and they only realised 2-3 weeks in to the consultation period. Well, if they then send that information in, and it's a whole load of appendices that details out the heritage, that's for you guys as a planning authority to consider, is this substantive information? And if it is, there's going to be a need to trigger a further round of consultation in relation to that. So if you receive additional information after the original EIA, notices, publicity and consultation has begun, you are required to repeat it. So that determining whether new content on the environment from the developer after it's submitted its EIA report is substantive information, that is the important factor as to whether you're going to be doing another consultation or not. If you determine it is substantive, it therefore becomes additional information, and you're then required by the regulations to repeat those consultations that we've just talked about in terms of steps 3A, 3B and 3C. So let's move on now. We've got the environmental information, that's great. What do we do with it next? Well, this is where we examine it as planning officers and start looking through it. And equally, we're then moving on to deciding, do we need to ask for supplementary information? I should say supplementary information is, it isn't a requirement. There isn't an expectation. There isn't a step that says you have to do it. It is something that you guys need to decide, and it should be driven by the answers you're looking for from in order to make your reasoned conclusions. But we'll come on to that. Let's look at examination first. So since 2017, we've had this expectation that the planning authority will examine the EIA report and the other environmental information. So that's the representations, the additional information, any supplementary information requests, etc. Examination implies it's going to be more than consideration. So pre-2017, our EIA reg said we should consider the environmental statement, as it was called at the time, and this other environmental information. 2017, we changed the phraseology to examination, and I think it infers something a bit more from us. We're meant to be making a kind of thorough and detailed analysis across the environmental evidence that's related to the proposed development. So ultimately, what we're trying to do is make a kind of professional, very much planning judgments as to what are our reasoned conclusions on significant environmental effects. And if we're minded to consent, then are there mitigation or monitoring requirements that might need to be conditioned in relation to significant adverse effects? So we're very much thinking about a kind of critical judgment beyond just summarising what the materials have said or a general review. We're meant to be, kind of getting into the nitty-gritty of this, but it is a judgment. We're not expected to be, the expert in that particular species, etc. So the examination is meant to result in these reasoned conclusions, the planning authority's reasoned conclusions on the significant effects of the development on the environment. So your judgment here around significance is really fundamental to making both a compliant but particularly an effective examination to get this information into the actual decision. So what you're trying to do, we should always be trying to make reasonable and rational judgments related to the EIA. So, don't get transfixed by one piece of evidence when there's a whole bunch of other things that are highlighting there's a whole load of risks here. Look across, try and take a step back. You should be able to justify, therefore, your decisions based on the evidence that's available. So it might be a particular part of the evidence that you feel is more compelling than some other part of the evidence. There might be a difference between what SEPA is saying and what the EIA report is saying, and you might feel more compelled by one or the other's evidence, but you should justify your judgments based on that evidence. You need to consider across those different opinions and that evidence. And of course, in making the planning authority's formal opinion, there needs to be a kind of clear feed into the decision process. So if it's going to committee, there needs to be this content into the committee reports. But ultimately, this is about using your existing planning judgment skills that you're using on a day-to-day basis, but just in the context of this weird world of EIA environmental evidence. And there's going to be an awful lot of that evidence. Since 2017, we have had this expectation put into the regulations that the planning authority should have sufficient expertise in order to conduct this examination. Now, there's no further definition within the regulations. What does sufficient expertise mean? But we either have it in the planning authority or we can access it access it from externally in order to help make our reasoned judgments. Now, in terms of accessing it from externally, obviously you need some kind of budget for that if you're going to bring someone in to help with your review of the EIA or perhaps a particular topic area or particularly kind of contentious area. But of course, you're going to need some budget for that. So in most cases, it is going to be the sufficient expertise from you as the planning officer, but also kind of conversations with your colleagues. And there may well be, you may have ecologists, archaeologists who you can speak to within the authority itself. As I say, it's not defined further in the regs, but clearly it's a lot less than the expectation on those producing the EIA reports. You're not expected to be a competent expert in biodiversity or in human health or in water effects or those kind of things. So it's meant to be about, having that understanding of the procedures and regulations and applying your sound planning judgments. If you can do both of those things, and hopefully the course is, helping you with what those procedures, regulations, good practice are, then you should be on pretty good ground. So it's not about being an environmental expert, it's about being able to focus onto the application of your judgment, recognizing, I recognize, this isn't easy, but some issues are going to be very technical, there will be uncertainties, but ultimately it is about you making a reasoned planning judgment on the evidence that's there. Of course, sometimes the evidence might not be there, but what can help us to understand some of those areas? Well, for a number of those areas, there is professional guidance, often produced by ICEP, which was formerly the EIA, but also by various others, CI, Chartered Institute for Ecology and Environmental Management, Landscape Institute, and some of the heritage bodies. And there are these guides out there that will often be referred to in EIA reports as, we applied this methodology or that methodology. It is worth noting, they are from separate professional bodies. They haven't been produced in an entirely collaborative way. So there are some variations in significant methodology between, what the CIM's ecological impact assessment guidance would say about how to kind of structure and think about ecology, significance for ecology, and perhaps how landscape or visual significance issues would be considered. And equally, the terminology high, medium, low, major, moderate, minor, may be different between these documents as well. To an extent, you've just got to kind of read across those, but it is useful to be aware that there are these guides, and if you do want access to them, then you can potentially have a look at those or give some reference to those if they're being highlighted as part of the process. If there's a disagreement perhaps between a statutory consultee and the EIA report as to whether a methodology has been followed appropriately and therefore whether the significance conclusions are right, you could have a quick scan of one of these documents to see, okay, does it appear that they have followed the methodology? Does that mean I feel I'm comfortable in making my decision? Or the other point you can get to is this opportunity to request supplementary information. Now, it's not a requirement for you to do this. Supplementary information is defined in the regulations. It's a component of that defined term, additional information, and it's something that you may request. Now, the real aim for making that request under Regulation 26 is it should be about a matter to be included in the environmental report, or effectively to supplement the environmental report because you've already got it at that point, that is directly relevant to reaching a reasoned conclusion on the significant effects of the development on the environment. So it's not a fishing exercise or a delay tactic for you as a planning authority. It should be something that you're saying, well, I need to make a significance judgment on this particular issue, and there seems to be some missing information, or there seems to be an area where some additional content from the developer could help me make that decision. But if you think you've actually got enough information to make that decision, even if there is a degree of contention between different parties or different representations, you don't have to go for a supplementary request. The outcomes of that request are the developers required to provide that supplementary information. So if you make that request, they're required to produce it, and you guys are going to need to repeat the formal EIA notices, publicity and consultation. Therefore, there is going to be a time lag consequence developer will have to go off, produce that information, submit it to you. There will have to be organising those notices, the publication in the newspaper, and then the 30 days for each of the parties to have the opportunity to make representations on that. It is worth noting under Regulation 26.4, you may in writing require such evidence of the EIA report or additional information that you feel is reasonably needed to verify information that's contained in the EIA report. But I'd say, if you're doing that, if there's been some questions in terms of the validity of the content within the EIA report or additional information, really make sure that's linking back to a significance conclusion rather than, kind of dotting I's or crossing T's, which, isn't necessarily helping anyone. If we feel we can make those significance conclusions, we should be moving on to the decision, but we do have this power to make these supplementary information requests. So let's think a little bit about what guidance is available and some hints and tips on this before we move on to just the final area of the actual decision and notice. In terms of guidance, there are some useful guides out in Scotland in relation to this. Circular 1 2017 from Scottish Government and PAN 1 2013 are useful here, particularly Circular 1 2017 in terms of setting out the process. I think this is where the EIA handbook from Historic Environment Scotland and Nature Scot really comes into its own. Chapter D and E has about 30 pages of information about this process and the different steps, and can be very useful to look at as well, and that's obviously freely available on their web pages. Looking slightly wider beyond Scotland, then down in England and Wales, the Planning Inspectorate for its nationally significant infrastructure projects has Advice Note 7. And the bit of this that might be useful for you to think about is PINS, or Planning Inspectorate, sets out within that what they consider to be a good environmental statement. The England and Wales still use the old term environmental statement rather than EIA report, and they list out a series of bullets as to what they'd expect to see in an effective EIA report. So that might be useful, if you're particularly interested in EIA, in taking a look at that. Okay, so in terms of some do's and don'ts or some hints and tips around this. So for you as a planning authority, you're doing an examination of an EIA report. What's some useful thinking? What's a useful approach? Well, personally, and this is just my advice, from my experiences and perspective, starting by understanding that non-technical summary and the development is really, really important. The non-technical summary should give you a quick, clear, accessible kind of heads up as to where the real environmental nuggety issues are and where the also runs are within the document. You can't necessarily rely on it 100%. You do need to check the main document, of course, but starting here is going to give you, an accessible view. It's also really important to understand the development itself. What is the development? What are its construction activities, its different operations, so that you can appreciate where the interactions, where those significant effects with the environment might come from. Some projects are going to be much more about their operational issues and maybe risks from emissions from them or spills. Others might be much more about construction and the access to the site and the roads for that, or whatever else. Other things, need to examine all the topic chapters, but you can prioritize those. You can prioritize those to which are the ones that carry most of the significant adverse effects, or which are the ones that are already likely, kind of appearing to prove controversial, either because you've got some responses in or you're aware from the scoping process. So, you don't have to spend as much time on every topic chapter that's in there, and some of the longest topic chapters might not necessarily have the most significant effects. It might just be the methodology that's required or expected of that chapter leads to a longer set of documentation. Hence, using that non-technical summary, jumping into the back end of the chapters and looking for the significant effects is quite important. And that's my third hint there. Start with the key findings for you as a planning authority. Your outcome is you want to know significant effects, you want to know mitigation or monitoring that you might turn into conditions. So actually starting towards the back end of the chapter and understanding those, and then as you understand those, kind of going back in and reading the evidence that makes up for that is, quite a useful way of getting to the key material for yourselves. And working back into the evidence, to help satisfy your understanding of those judgments, how that compares to representations, etc., can be quite useful. In terms of some don'ts, in terms of examination, don't wait for all the representations to be coming back before you examine the EIA reports. You know, that's 30 days that's gone. It's a big document. You're going to need to get in there. I certainly wouldn't advise it starting at page 1 and just reading to the back of however many thousand pages or 100 pages there might be. Use that advice above, find your focus to those significant effects, understanding the development, etc. And don't assume that you have to make a supplementary information request. If you feel you've got sufficient evidence to make your significance judgments, then make that case and move forward. If you do feel there is a need for supplementary information, then obviously use the advice that we just talked about. So once we've done all of that, you've done all the work, we need to integrate the reasoned conclusions on significance into the actual consent decision. So what are we doing in relation to that? Well, EIA is a decision support tool, but it is procedural, so we need to make sure that everything that we've done, the findings of this, are available and in that actual decision-making process. But the information that is there is highlighting to the decision makers, these are the environmental risks. Do you want to move ahead with this or not? So in all cases, your reasoned conclusions on the proposal's significant effects on the environment, they need to be integrated into consent decision making. So that's obviously in most cases, if it's going up to the planning committee to make that, it's going to be making sure that's in the committee report, making it clear the applications and EIA development, clear that you've delivered your compliance requirements, setting out these are the significance conclusions in terms of your examination of the environmental information. And one thing the regulations require is to state or to indicate that your conclusions, those significance conclusions, are up to date at the point of decision making. So that's something that you want to state there. That up to dateness is a judgment that you guys need to make, and we can perhaps talk about that more in other sessions. We're going to cover cumulatives on the 26th of March, and it may well come up in relation to that. Obviously, if you're minded to consent, if that is, the recommendation in the committee report, then there is going to be a need to start converting some of that mitigation, monitoring of environmental significant effects into conditions. And when we're looking at that, turning EIA mitigation into planning conditions, if we expect we're going to grant that condition, what should we do? We should seek to turn environmental design features, specifics of the design that help avoid or prevent effects or mitigation things into conditions. So they might be sourced from the EIA reports, they might be from some consultee representations, they might be your own judgments. Of course, the challenge could be, and where you might end up spending quite a bit of time, is turning EIA mitigation, which is written by an ecology expert in marine mammals or kind of a particular water role or whatever else it is, into something that meets a planning condition that meets all of the tests, the necessary, relevant to both planning and the development, precise, enforceable, reasonable. So there is going to be a need to do that, but at the same time, we need to make sure that the intended kind of environmental protection or mitigation, or the intent of that environmental mitigation in the report or from the representation, is actually achieved once we've got our worded condition. The other thing we need to be aware of is that if there are significant adverse effects, we are required to consider whether we're going to impose any monitoring conditions in relation to those. So are we monitoring the environment? Are we monitoring the mitigation to make sure it's implemented? Are we monitoring the implementation once implemented to make sure it's actually delivering what we expected? And then finally, before we move on to the Q&A, and apologies, I've overrun ever so slightly versus my intended timings, there are some requirements in the decision notice. Just one slide here, but it is important. It is part of the procedure. Remember that definition of EIA, the integration of those reasoned judgments into the decision notice. So after all of our EIA decisions, whether it's granted consent or whether it's refused consent, there is EIA expectations as to some of the information that should be available either within or alongside the decision notice. So if some of this is already covered in the decision notice, that's fine. You'd have to do something separate. But if it's not in there and it's an EIA application, add it in there or make sure it's available. Your reasoned significance conclusions behind the decision need to be there in all cases. If it's been granted, Then the environmental conditions should be set out, any environmental design features should be set out, and a summary of the consultation responses. If it's refused, it's your reasons, your significant conclusion reasons, and if any of those have been driven by the significant environmental effects, and also the fact that the developer has the opportunity to challenge that decision. There's also a duty not just on the decision notice, but also in terms of informing those parties who've been involved in the EIA process, and that unfortunately falls to you. So the Scottish ministers, the consultation bodies, any other bodies that you consulted on the EIA report need to be told effectively the information that's in the decision notice, and then we need to make the notice available for public inspection via the website and local advertisement. So you get the choice here. Obviously, putting it on your website going to be far cheaper than local advertisement. It is an or in relation to making sure the public can expect. It is worth noting where the Scottish ministers make the determination, it still falls on you. So the Scottish ministers have to provide that information, but it's your responsibility in the regulations to make that information of that decision out there. So that's worth noting. That's where I'm going to end today. So just in terms of our learning review, hopefully you now have better understanding of what the requirements are of that EIA report in terms of kind of having at least a brief check to see does it meet those core requirements as validation, what you're going to do to manage the actual application, post-submission, the consultation, the notices, and then once all that's come together, you've got the environmental information and the advice we've given you in terms of examining that and some good practice advice, focusing on significance, and then also your roles around additional information should the developer submit additional content or supplementary information if you choose to request any. And then, of course, we just touched off with what to do at decision and post-decision communications.